Hi, everybody, and welcome back to another episode of Green Scare Pod. So, today we're joined by Lauren Regan of the Civil Liberties Defense Center, a nonprofit working to combat institutions perpetuating social and environmental injustice. We're very lucky to have this refreshing perspective today because Lauren is an attorney who has defended numerous Green Scare activists and has much experience with state repression, something we're seeing a lot more of in this current political context. So, thank you so much for joining us today, Lauren.
Sure. Thanks for having me.
All right. So, what first got you involved in the animal liberation and environmentalist struggles?
Well, I think when I was like 7, I announced to my parents that I was going to become a veterinarian or an animal lawyer. And so I have had sort of like a lifelong, love of animals that sort of morphed into environmental and forest defense when I, kind of got to high school and college. And so when I was trying to think about how I could be most effective, within those movement spaces, I realized that I had skills and privilege that would allow me to go to law school and sort of fill what I saw as a glaring gap within our movement spaces. So just basically went right from undergrad to law school and have been doing movement law for 28 years now.
So, would you say that your activist identity played a large part in your decision to go to law school?
Oh, definitely. I mean, the reason I went to law school was to better serve the movements that I was already a part of, for sure.
Right, right. So, on that note, what was your role in defending activists from legal repression during the Green Scare? And which activists and cases did you notably defend or assist in the defensive?
Well, so I went to law school at the University of Oregon School of Law in Eugene, Oregon. And I was in law school from 1993 through 1996. So I was living in Eugene and connected to the environmental and animal rights movements within the Northwest during, what basically became the height of repression. There were a series of reasons that that came to be, including the salvage rider was passed by Congress, which suspended all environmental laws and basically allowed for like full-blown lawless logging, within the old growth forests that I lived near and, was defending. But also from about like 1986 through 2001 or so, there were a series of acts of economic sabotage where communiques were left by various cells within the ELF and ALF, regarding arsons that caused no harm to any living thing. And as a result of that, there had been ongoing investigations into these communities for a long time. Um, and I came out of law school right around the time period, leading up to like the WTO protests. And, long story short, around 2003, maybe 2002, the FBI started openly making its presence known within more radical activist spaces, especially in Eugene. We had lots of knock and talks and grand jury subpoenas being issued and infiltrators and feds and, all sorts of things that were happening, like literally as I was earning my chops, as a
Hmm.
brand new movement lawyer. And so then in 2005, um, the largest roundup of environmental and animal rights activists occurred under Attorney General U.S. Alberto Gonzales. And in that roundup, included friends of mine and
Hmm.
people that I had worked with and clients. And My roommate at the time, her boyfriend, was one of the people. She ended up becoming one of the snitch cooperating defendants in that case. So,
Would this be Lacey?
yeah.
Okay.
Yeah, so there were friends and clients and, all sorts of people roped into this. Officially, I was the attorney of record for Jonathan Paul
Hmm.
during the Green Scare prosecutions. At first, he was grand jury subpoenaed, um, and then as a result, basically, of one of the defendants, Jacob Ferguson, becoming a
Mm.
snitch, that grand jury subpoena was dissolved and turned into basically an indictment. And he was indicted for conspiracy as well as the Cavill West horse slaughter facility action. Um, and then I also helped to coordinate a joint defense legal team for the non-cooperators. And in essence, the idea of that is that everyone that was a non-cooperator, regardless of who their attorney of record was, had the benefit of all of us, putting our heads together in defense. So that included um, Daniel McGowan, who is still one of my very good friends. It included two individuals who, were super young and not super involved, Sadie in
Mm.
Exile. And originally it had included Darren Thurston, although he later became a snitch and left the joint defense boat. See. So, later Marius Mason ends up being snitched out by her ex-husband or their ex-husband at the time.
Mm.
And Marius becomes a defendant in Michigan, and I support his legal team. Uh, you know, he has transitioned to male. That is,
Yeah. On that note,
correct.
he's recently been moved back to a female prison, so I will be
Of
leaving.
course.
I will be leaving support material in the description, and I highly encourage all viewers of the show to write to him in support.
Yeah, I represented several grand jury resistors throughout this
Mm.
time period, helped with media outreach and, prisoner support organizing. I and a few activists did a national road show around the country talking about the Green Scare and state repression. At one point, I did a national road show with Robbie Mirapol, who is the son of Ethel and Julius Rosenberg. And we
Mm.
did a roadshow comparing and contrasting the Red Scare to the Green Scare
Wow.
around the country, which was interesting, kind of bringing that older generation into solidarity with this newer generation of
Hmm.
targets. Just generally really working hard on like intersectional support, bringing the legal community into support. Like, it was an all-encompassing major aspect of my life, both career, work-wise, but also personally, just because so many relationships were destroyed as a result of
Mm.
the situation. Communities were divided, and yeah, it was a rough time period. But I think at the end of the day, I think one of the important takeaways is, for myself and Daniel and Jonathan and, the non-cooperating defendants and grand jury resistors, we are still alive, we're still activists, we're still able to continue to work together and struggle. And even though that time period was super hard and caused a lot of harm and damage, the federal government, with all of its time and money and power and resources, was unable to like fully crush um, that aspect of the movement. And there were unprecedented resources put, to the
Mm.
targeting of this case. When these actions happened, if you were to have asked me, what was the worst case scenario, I would have said, oh, you'll end up with a federal arson charge and you'll do about 3 to 5 years in prison. But in the intervening time period, 9/11 happened and the Patriot Act was passed, and the federal government couldn't catch, Osama bin Laden. So they sort of reframed targeting quote unquote domestic terrorists and, basically trying to make bunny huggers, the equivalent of Al Qaeda because that was their PR spin. So no one could have predicted that that would have played out that way. And I would say, like, not only did it create huge amounts of money and investigative tools being, put toward that, but also when it came to like the punishments for these folks, for the first time ever, the federal government attempted to seek the terrorism sentencing enhancement
Hmm.
against defendants who didn't kill humans. Up until that point, that enhancement was only used for like mass acts of murder, like the Oklahoma City bombing, and sort of big
Hmm.
things like that. The sentencing enhancement was created so that the federal government could better track mass murder, incidents. And so it had never been used for mere property damage, arson cases like this. But the federal court basically ruled square peg in round hole, and a number of folks ended up with that terrorism enhancement, including Daniel and many others. Fortunately, we were able to successfully argue that Jonathan did not have that sentencing enhancement. Um, and I think the only reason that we were successful in that is that he was charged only with engaging in an arson against a corporate entity,
Hmm.
not a governmental entity. A lot of the others were sort of
Oh,
like
that makes
government
sense.
property. And that's where sort of the distinction came about. I mean, we could talk for hours about that case, and how consequential it was, both legally and like movement based, but I will leave it at that unless you have follow-up questions.
So, how much of a role did informants and snitches play in sort of dismantling the radical green movement at that time? And what was it like to see people succumb to the pressure around you?
Yeah, well, so the first person that succumbed was Jacob Ferguson.
Mm.
This was a long time person involved in forest defense and environmental activism. He literally had a pentagram tattooed on his forehead. And if you were to have tried to predict who was least likely to become a federal informant, most people would have been like, well, yeah, Jake. But he also had a heroin addiction
Mm.
and was super paranoid at the time
Mm.
and just was having a lot of issues and literally due to that, like lawyered up and walked into the FBI US attorney offices and said, promise me that I won't go to jail, and give me 150,000 bucks and I'll tell you everything you want to know. And from the documents, I think the FBI was like, oh, maybe this guy is involved in like one of the arsons, but it turned out that he was basically involved in almost every one.
Yeah.
And so when he started doing his snitch talk, his proffers, as they like to call it, the government just became giddy with delight over the extent of information that he was able to provide. And so pretty quickly, they got him wired up and sent him around the country in an attempt to entrap potential co-conspirators and co-defendants. And because of like who he was, many people fell for him, showing up in
Right.
New York or other places and be like, oh, I'm just here for my mom's wedding, or I'm just like checking my PO box. By the way, let's do a stroll down memory lane, and talk about the good old days, all the while recording it. And so when that big roundup happened, there were individuals sitting in jail cells, and the feds would literally parade Ferguson past their jail cells, signaling to them that Jake is our man. He's already snitched
Wow.
you out. you might as well become a snitch too. And unfortunately, even though these individuals were engaged in really high risk, radical direct action, they succumbed to these very standard old plays that the government uses, in these circumstances. And many of them just drank the Kool-Aid and basically were like, oh, the gig is up, so I'll just join Team Snitch. And even though there was a very clear team non-cooperation, these were individuals that allegedly like took blood oaths of loyalty to each other, not to snitch on each other and stuff like that. And, here they are, almost a decade later, and they are falling all over themselves, racing to the snitch booth in order to get as much time off their own personal sentences as possible, which really didn't end up resulting at all.
Mm.
Statistically, when we looked at everybody's sentences, the non-cooperating defendants on average got about 18 months of additional prison time beyond the equivalent snitch. So they paid an 18-month tax to have integrity, to be able to return to their political movement, and to not basically succumb to the federal government, in a way that they were allegedly adamantly opposed to, ethically and politically. So that weakness, that pathetic failure of a number of those folks was certainly a significant loss to the movement, was a black eye to the movement. It showed the feds, it showed the government and the state that by just applying the tiniest bit of pressure, they could roll this radical fringe of the movement for the most part. It was a minority of defendants that remained true. But when we started working on those cases, the government was basically like, there will not be non-cooperation plea deals. You will either snitch
Mm.
or you will go to trial. And our clients were facing like life plus 1,115 years in prison for the charges because they were so trumped up. But that was also a bluff, and a lie. And ultimately, we did negotiate non-cooperation plea deals for our clients, that, like I said, really only resulted in, minor incremental additional time given the scheme of things. And even though they were threatened with life plus 1,115 years in prison, they got between 3 and 10 years of actual federal prison time, depending
All of
on,
them are with us here now.
yeah.
And
And
it's interesting, by the way, that you mentioned Jake Ferguson. Firstly, because good friend of the podcast, Peter Young, recently talked about how he actually met Jake very closely before he was picked up. So that's how close that hits to us. But I specifically remember seeing in Marshall Curry's documentary about the ELF that the FBI pretty much admitted they didn't even have anything on Jake Ferguson to convict him, much less anyone else. And it was
that's
only
right.
him approaching and confessing everything outright that led to this entire dismantling of the
Yeah.
movement.
Yeah. I mean, like I said, the feds really had no actual named individuals at all. And even with Jake's, extensive snitching, he didn't know everybody's names, so
Hmm.
there were additional snitches like Suzanne Savoy, for instance, who actually like named Sadie in Exile, and got them roped into it. Like, so, and a lot of the snitches will say things like, well, Jake had already snitched, so it wasn't like I was giving them anything new. But
Hmm.
Jake was a heroin addict, who was a completely unreliable witness. If the government only had Ferguson, they would not have had a case to really bring to trial. If every defendant had remained on team non-cooperation, the outcomes of these cases would have been vastly different. Because in fact, the individuals involved actually had done a pretty good job of um, maintaining confidentiality and, you know, the level of investigative tactics were not the same level of sophistication as they are now.
Mm.
So without Jake Ferguson being the initial roller, they wouldn't have really had anything. And once others started corroborating Ferguson and adding, they all added, every single
Mm.
stitch added something that Ferguson had not said before. Um, you know, for instance, like you mentioned Lacey Philibom, Lacey Philibom and Jennifer Kolar, both testified at trial against Breonna Waters, a non-cooperating defendant who was prosecuted in Washington. Washington refused a non-cooperation deal, so Breonna went to trial. Literally during breaks, she would leave the courtroom and breastfeed her infant and then come back in to basically be tried because she stood staunchly against cooperation. When Philibom took the stand to put her in prison, to snitch against her in order to try to get less punishment for herself, Philibom literally, I'm sitting next to Brianna, I'm part of her legal team, and Philibom basically stated on the witness stand that we were roommates and that either I knew or should have known that she and others were engaged in arson, which was completely not true. Like I was absolutely shocked that this person that I was living with, was actually a journalist, was
Right.
actually involved in being a lookout, at some of these actions. But she literally tried to take me down as well as put
Wow.
Brianna in prison during that trial just to try to like get a few more days or months off of her prison sentence for, actions that she knew the risk. She was a very smart person. She knew the risk before she engaged in those activities, but certainly was not willing to do the time, once, came home to roost, so to speak.
So, have you ever faced conflicts between your ethical obligations as a lawyer and your beliefs regarding radical forms of activism, such as direct action?
Um, Well, I mean, I would not publicly advocate for breaking the law as a lawyer, but I am able to educate people about where the line is drawn between legal and illegal.
Mm.
So yeah, I mean, as a member of the bar, as a officer of the court, as someone who with a magic card can walk into jails and hug my clients, there are definitely limitations on, what kind of advocacy I could do. And
Mm.
especially as a movement lawyer that represents lots of radical cases, I am extra careful about ensuring that I don't, you know, give them an easy way to like take my bar license away or to
Mm.
prosecute me. Um, you know, there have certainly been cases that I've been involved in, including the Green Scare cases, where threats were made, to me personally and to my bar license. And, um, it's just by taking a breath and being really strategic in how I engage. Um, I have managed to do this for 28 years. My personal beliefs have obviously um, formed the basis of the dedication that I have committed to being a movement lawyer and to be able to defend, people who I, care for and who are taking great risk to mitigate suffering, which is a core ethic that I, hold as well. So I guess that is how I would answer that question in a public format.
Well, that is all you can do for us, so thank you for that. So back to the Green Scare, the War on Terror was one of the primary factors which led to the creation of the Animal Enterprise Terrorism Act and the persecution of animal rights and environmentalist activists. So, what other social factors were at play too around this period? You mentioned the Oklahoma City bombing and 9/11. as sort of as terrorist incidents that had big effects in the American consciousness. I'm wondering what other factors do you think led to that as
Yeah,
well?
I mean, I worked hard um in like 2005, 6 when the AETA was being proposed,
Mm,
because at that point we had the Animal Enterprise Protection Act, the
mm,
AEPA, and at that point the Shack 7 had been indicted, and that case was underway under the predecessor. From my recollection at the time, the substantive change that had happened is that big pharma, predominantly big pharma, had put huge amounts of money and funding and lobbying into protecting their profit industry.
right.
There had been a number of successful campaigns specifically targeting HLS,
Mm,
one of the largest, vivisection labs on the planet at the time. And activists had become relatively successful in those campaigns. And historically, whenever movements and people's campaigns start to have successes, that is when you will see the state really trying to ratchet the screws, and really bring any power they can to bear. And so in this instance, my belief is that corporations and lobbyists put themselves in the same boat and really weaponized the legislative process by turning the APA into, again, using that boogie word at the time, anything that was left would have like the word terrorism thrown into it, in order to try and like affirm that like their stereotyping or their labeling of activism as terrorism was somehow actually correct. They thought the more we say it, the more people will believe that it's true. And particularly because there still was a lot of control of mass media by the government during this time period, it really was challenging for us to sort of combat that labeling, of activism or dissent as terrorism. Though there were a lot of campaigns around the country, where I think people were pretty effective at trying to combat that. Campaign slogans like, if everything is terrorism, then nothing is. If everything is terrorism, America is less safe. I mean,
right.
across the spectrum from rad to very moderate, there was pushback that was happening around this time period. But ultimately, the AETA was passed as part of a basket bill, which
Mm,
means it had no hearing and it was never individually voted on. It was thrown into this like basket of bills that included like money going to the families of Oklahoma City federal workers that had died in the bombing, And so they put
wow.
it in this basket where like no elected rep was basically gonna say, boo about it. I think Earl Blumenauer was like the only elected congressperson. When he found out that the AETA was going to be part of this basket bill, he literally ran to the floor of Congress trying to like make a speech against it and, sort of calling out how fucked, it basically was. But
Yeah.
he was too late and overwhelmingly outvoted. And it's that undemocratic bullshit process is how industry and its cronies, get some of these unconstitutional bullshit laws passed in dirty dog, tactics. After that, we tried challenging the constitutionality of it in criminal cases that ultimately were filed. CCR and others filed proactive civil lawsuits trying to challenge it constitutionally, and they were thrown out for like standing reasons, So basically, the legal merits of whether this law was constitutional or not really never actually got addressed by a federal court. And the law still exists, although, it has been rarely used in modern times. There was a time
Mm,
period where there were probably like a dozen different prosecutions, after the fact, mostly related to animal liberation, fur farm
Mm.
liberations. Um, there was one case where like literally people were accused of sidewalk chalking outside of a vivisector's home. But we were able to get those charges dismissed on First Amendment
The
applied.
AETA 4, right?
Yeah,
Mm.
yeah. And that was California too, much better court than some of the
Right.
others that have addressed it. But yeah, there have been a few folks, including like in Utah.
Mm.
I think there was like an Iowa case where people did end up either getting convicted at trial or taking plea deals to AETA.
Right. So, at least to me, it seems after that time period that we've had some periods of increased social liberty, and it's now been followed by a resurgence in oppression, like under the Trump presidency. How would
Mhm.
you say the legal landscape for green activists specifically has evolved since the Green Scare?
Well, I mean, I think you need to even look at the arc of history from a longer perspective. If you look at environmental and social justice action or activism going back to like the 20s, in the US, you will just see, exactly as you said, an ebb and flow of state repression, often correlated to the efficacy of those movements. That is the tug of war that constantly occurs between the people and state power. And for me, when I say state power, it includes big corporations,
Hmm,
are part of the state.
of
There's a
course.
revolving door of CEOs that become part of the government and then leave and become CEOs again. And so they are so interwoven and their interests are, so aligned that they are on the same team. And so um, I think the Green Scare, so, before the Green Scare happened, like, we shut down the WTO, in 1999, like there had been this like surge of efficacy within movement spaces.
Right.
Um, and a lot of victories, and major wins. And so it was not surprising that industry and government exploited 9/11 as a means to
Mm,
ratchet down and try to suppress that growing efficacy within the movement. And by and large, although they didn't destroy it, certainly within like the environmental and animal rights realm, they were able to suppress the efficacy of those movements post Green Scare.
hmm.
Many people were, chilled from activism and associations as a result of it, despite all of our best efforts to counter that. And although they didn't completely snuff out, activism, it certainly is, you know, verifiable that they were able to take a blow to it for sure. And I would say that then you kind of saw recovery happening and, through at least let's say like the Biden era or the Obama Biden era, you saw like climate activists and Standing Rock and these big big pipeline resistance, climate resistance, other kinds of activism where people got popped and people went to jail and things like that, but overall those were planned and anticipated consequences of that activism for the most part. And those, mass movement spaces overall, I would say were pretty successful in achieving many of their goals, even if the actual pipelines were constructed. And so I would say that, you were seeing sort of an upswell again of mobilization movement size growing, the tactics and successes of those movements were really being felt. In fact, like the oil and gas journal at one point stated that the number one threat to the continued viability of their profits was the climate movement and its successful reputational harm that they were, basically creating for the oil and gas industry. When I read that in that journal, I was like, okay, this is where you're going to start seeing these multi-billion dollar industries putting their money, where their mouth is and really attempting to clamp down on, the ability of this movement to continue to harm their money, harm their profits, which of course is all that they care about. And
Right.
so, we did kind of start to see some of that. And now, of course, with the Trump regime, I think it could go either way. I think
Hmm.
temporarily, we may see a real clampdown, from this regime. Although right now it seems to be mostly focused on Palestine and immigration. At some point that, kind of spotlight could change, especially as actions around animal or environmental advocacy, get more national spotlight. Um,
Not to
and
mention the anti-Tesla actions.
yeah, which, the anti-Tesla actions, I wouldn't even clearly put in the environmental or climate bucket. I think that, that is a
Sure.
really good example of like a intersectional,
Hmm.
that is about, democracy
Of
and,
course.
a lot broader than just environmental, at this point. So yeah, we'll see. I mean,
I
I
just
think
could certainly see how that, concern might revive Green Scare type oppression and language and
sure. I mean, I
institutions.
think, there is a perfect storm that is possible. You
Hmm.
have mass movements that seem to be quite effective at causing economic harm
Right.
uh, to Tesla. And you've got, all of these unconstitutional bills or laws that have been passed, making mere misdemeanor level activism into felonies, critical energy infrastructure and, making it a felony to block a roadway. And, there's just
Right.
all sorts of things that exist where if they were tools to be used in any legal, unethical, kind of fucked up way, like those tools are laying on the table for the bad guys to potentially pick up and use. I do think that like lawyers, and activists are doing a really good job in readying the
Hmm.
battlefield for that next, chapter if it does come to play. But that doesn't mean that individuals won't be harmed in the
Of
meantime,
course.
you know.
Yeah.
Overall, what I would say, even with regard to the Green Scare, there were hundreds and thousands of environmental animal rights activists at that time period doing all sorts of things.
Mm.
And it was like 30 or less individuals who actually got hammered. They
Mm.
either had a grand jury subpoena or they went down, and went to prison. And that's not to say that those individuals, didn't suffer significant stress and harm, but in terms of the government's goals of trying to crush a movement, on the upshot, only 30 people went down out of thousands and thousands and
Indeed.
thousands.
Indeed. Yeah.
But on the downside, there was an effect. They only had to go after 30 people in order to have some effect on that mobilization arc of the movement. And that is certainly a lesson that they learned quite well. Pick the right snitch, and you basically can
Hmm.
make everybody else roll. And it only took going after like a dozen actual defendants in order to cause that ripple effect that they were looking for to some degree. And so from the movement perspective, like that is the key lesson, that I think we need to learn in terms of like when that next era occurs, how can we foster more resilience? How can we stand stronger? and persevere better through one of these eras. And, to me, doubling down on resistance in the face of it is the only way to teach the bully that this is not an effective tactic. An example I would give, at one point during the ATA 4 era, there were grand jury subpoenas that were being issued to animal rights activists, mostly in the California area. And those activists, were 100% going to absolutely resist those grand jury subpoenas and go to jail for it. At the same time, the government was going after a group of old Black Panthers for stuff that happened back in like the 70s.
Jeez.
And those Black Panthers, even though they hadn't spoken to each other in decades, they had been tortured while they were in custody, like all sorts of reasons for them to try to like save their ass and get out of it. They too stood 100% in resistance to the grand jury, and they too were going to go to jail. And we paired the animal rights movement and the Black Panthers together in a solidaristic show of resistance to state repression and grand juries. And all of those grand juries for the animal rights activists and the Black Panthers were dissolved, and no one had to go to jail as a result of that. That type of showing of 100% impenetrable solidarity is the antidote to state repression in so many ways. And as we saw in that instance, the bully went down. The bully backed off in that showing. But if they see a vulnerability, if there is an Achilles heel for them to exploit, then it's going to be a much tougher battle. You'll see that repression go on for much longer. You'll see more people roped in and potentially harmed, et cetera, et cetera. That wall of silence, is key going back, generations and generations with regard to political activism, in my opinion.
Absolutely. Loose lips sink ships. Um, how do we balance being effective and keeping our community safe? And what could we tell activists to make them less afraid under Trump?
Yeah, we have lots of webinars on the CLDC website around the topics of building resilience and armoring yourself against state repression as an activist. I think the most important things, though, is to know what you are getting into before you get into it. Understand the worst case scenarios and be willing to accept the consequences of the worst case scenario. You can hope for the best, but you need to be willing to eat the worst case scenario in the event that it unfolds. And if you are not willing to take those consequences, you should not take that level of risk. You should not engage in that level of risk. And I think everybody could do better with regard to like document hygiene, digital security, having safety plans, literally thinking through what would you do if you ended up with a knock and talk, a grand jury subpoena, an indictment, et cetera, et cetera. Even if you think that you are engaging in low risk activities or, like with the Green Scare, you think like, oh, I could get 3 years in prison for this. I could do that. 10 years goes by, your life has changed significantly. And now, you're looking at life in prison for that same action. Like that happens. And engaging in direct action, particularly economic sabotage level of direct action, is not for the faint of heart. That is a very serious choice and has potentially serious consequences and, needs to be thought of as a potentially life-changing decision that you are potentially making.
Absolutely. It's not a choice any of us here are advocating for, by the way,
Correct.
just only providing information.
I mean, there
So,
are so many different tactics that people can use that don't have that level of risk that are effective, and it really does, if you look at history, particularly like forest history, it's always been a combination of litigation, advocacy, education, outreach, as well as, nonviolent direct action, all the tools, as they say, like that really is important. And I think it's also kind of important for us to remember the St. Paul principles, when we are thinking about diversity of tactics and security culture, because, without foundational levels of trust and understanding, our movements are too weak to withstand the pressure that could be applied to them.
Right. So, now we have a viewer question coming from the good friend of the podcast, former ALF activist and animal liberationist Peter Young, and it is a very Peter question. What do you advise activists who may have committed crimes in the past about the statute of limitations? Is it ever okay and safe to disclose their actions publicly or privately?
Well, if you've been a defendant like Peter and others, and often as part of non-cooperation plea deals, you are given an opportunity to disclose any other crimes that you have committed, and by disclosing them, you can't be prosecuted for them.
Hmm.
And so, for those that have engaged in that, then if my view is if the government knows about it, then your community should and can know about it without consequences. Specifically regarding the statute of limitations, there's not a real black and white answer for that
Hmm.
because, although there are some general statute of limitations, for certain felonies and, and things like that, there are categories of felonies, particularly, crimes of violence, which could include arson, and
Hmm.
trumped up incendiary device types of tactics, where there really is no statute of limitations. At least arguably, the government believes there is no statute of limitations. So it would really depend on, what's at play, what's in your head, and if in doubt, like I mentioned just a minute ago, you need to think through the worst case scenario, which is potentially, being indicted for something that you disclose. So the Civil Liberties Defense Center has been around for over 20 years. We defend environmental and social justice activists for free, whether that is federal or state criminal charges, whether it's SLAPP suits where corporations sue activists, or whether it's proactively suing the government or law enforcement for violating the civil rights of activists.
Hmm.
We are a small organization, so we are pretty selective in the cases we take. We really try to like take cases that we feel like are going to have impact beyond an individual. Um, and we take on a lot of the cases that like others won't take on for various reasons. And we've had unusual successes, taking cases to trial and winning, acquittals for clients or getting, civil judgments, getting slap suits dismissed, stuff like that. Um, the CLDC website would be the best place to go to like see all the types of work that we do and all the different resources that we make available. And there is a way to contact us through that website. If somebody needed specific support in a way that they don't easily find on the website.
All right. Well, thank you so much for joining us today, Lauren. This was such an interesting episode, and you really gave us such a refreshing look because we typically don't have legal professionals on the podcast. So, yeah, seriously, thank you so much, and thank you so much both for coming here today and for all of the work you do. Really.
Yeah, thanks. It was
All
great to
right.
be here.